All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-04, the Specialist Prosecutor versus Pjetër, Shala.
Thank you, Madam Court Officer. Now I will kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honor. Today the prosecution is represented by Alex Whiting, Deputy Specialist Prosecutor, Margot Portier, Associate Disclosure Officer, Arthur Sirbo, Associate Legal Officer, and Moira van der Poel, our legal intern, and myself, Filippo De Minicis, Associate Prosecutor.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Gillissen, please.
Thank you, and good afternoon, Your Honor. Good afternoon to my colleague, including Mr. Simon Laws, we are seeing for the first time, and for all the people who are inside the courtroom and in the public gallery. So I am Mr. Jean-Louis Gilissel, counsel of Mr. Shala, who is with us today by video link. And as usual, I appear before the court with Mr. Edi Awini, my co-counsel. We are assisted by Ms. Zeneta Petrovica, our team's manager, and Ms. Anka Joanna, our last intern. We are here to assist Mr. Shala, and we are at your disposal, Mr. President.
Thank you, Mr. Gillissen. And for the record, I note that Mr. Shala doesn't attend the hearing in person, but attends via a video link. Now I turn to the counsel for victims. Mr. Laws, please.
Good afternoon to Your Honour and to everyone. I'm Simon Laws and I'm assigned counsel for the participating victim in this case.
Thank you, Mr. Laws. And now I turn to the registry. Mr. Nielsen, please.
Good afternoon, Your Honour. Jonas Nilsson, Judicial Services Division, representing registry today.
Thank you, Mr. Nielsen. And for the record, I'm Nicholas Guillou, Pretrial Judge for this case. On 9 February, I scheduled this sixth status conference in this case. My goal today is to review the status of the case and to start preparing the transmission of the case to the trial panel. In particular, I wish to discuss disclosure, translations, the status of the specialist prosecutor's investigations, the status of the defense investigations, the points of agreements on matters of law and facts, and finally, any issues the parties may wish to raise. I thank the SPO and the defense for their written submissions ahead of this status conference. And as usual, I will invite the parties to present their views in a concise fashion about each item on the agenda, which I will address individually. But before addressing these matters, I would like to discuss two preliminary matters. The first matter is the latest defense request for extension of time for detention submissions, which is filing F00160. I recall that in line with the decision of the Court of Appeals of 11 February 2022, I invited the defense to inquire into the willingness and capacity of the Kingdom of Belgium to implement any conditions of release it has proposed and/or any additional conditions. In the same decision, I further ordered the defense to provide submissions on the next review of detention of Mr. Shala by no later than 2nd March 2022. In this regard, I note that the defense requests an extension of 4 weeks to submit its submissions for the next review of detention of Mr. Shala, so as to obtain and assess the position of the Belgian government, as well as to provide the defense position on these matters. I would like first to ask the SPO whether it has any submissions to make in this regard. Mr. Prosecutor.
Thank you, Your Honor. The SPO does not oppose the defense's request for a postponement of the filing for the detention review.
Thank you, Mr. Prosecutor. Mr. Gillissen, do you want to add anything, or Mr. Ayuni, to the written filings? It's not necessary to repeat. It's just if you have anything to add.
Thank you, Your Honor, and good afternoon to everyone. Just to point that we received a preliminary response pertaining to logistics. So we have to go through a different channel, which is accepted by the Kingdom of Belgium. We have processed with the sending of the new correspondence in that regard, and we think that our submissions will be more effective once we receive a response. Thank you, Your Honor.
Thank you, Mr. Ayuni. Having heard the parties, I will issue a first oral order. I note that the defense has not yet been able to obtain information and make satisfactory progress with its inquiries with the Belgian authorities. I further consider that this information and the defense submissions are required to address the decision of the Court of Appeals of 11 February 2022 and to review Mr. Shala's detention. Lastly, I have taken note of the fact that the SPO does not object the requested extension. In these circumstances, I consider that good cause within the meaning of Rule 9(5)(a) of the rules has been demonstrated, warranting the requested extension. In this regard, I observe also that Mr. Shala has waived his rights to have his detention reviewed before the expiry of the 2 months time limit set out in Article 41(10) of the law and Rule 57(2) of the rules. Accordingly, I hereby order the defense to provide its submissions by no later than Wednesday, 30 March 2022. The response and reply shall be submitted in accordance with the timeline set out in Rule 76 of the rules. This concludes my first oral order. The second matter I would like to discuss is the request from the Victims' Council, which is filing F00151. And for this, Madam Court Officer, can we go into private session, please? So, Mr. Laws, I'm informed that due to the fact that you attend remotely, unfortunately, you cannot attend a private session, which is problematic because this concerns the request that you made in filing F00151. So, I'm unable to give you the floor on this, but I think you do not need to add anything to this filing. I will probably ask the parties if they have anything to respond to this filing. If they have, we will not have a discussion today, and this will be done by written rulings. If they don't have anything to respond, then written ruling is an oral ruling is possible. And I may give a couple of minutes to the parties if they want to review the filing. No, I see the prosecutor who tells me that he's ready. Mr. Prosecutor, just very generally, no detail about the filing, just if you have any comment on this, please. And if you have, then we will not proceed.
We support the relief requested by Victims' Counsel, Your Honor.
Thank you, Mr. Prosecutor. Mr. Gilisen.
Yes, Mr. President, we defer to the wisdom of the court. Thank you.
Thank you very much, Mr. Gilisen. Thank you to the parties. I will now move into private session, and I will ask the registry to keep the transcript for Mr. Laws.
Your Honors, we're now in private session and the outgoing audio is muted to Mr. Laws.
Thank you, Madam Court Officer. I will now issue my second oral order. Considering that the victim participating in the proceedings confirms that he seeks anonymity towards the accused and the defense, I hereby order the continued application of the protective measures under Rule 84D and E1 of the rules for the reasons identified in paragraph 37 to 40 of my decision of 15 December 2021, without prejudice to the variation of these measures at a later stage, including by the trial panel, if and when the need arises. Furthermore, Victims' Counsel shall submit a public redacted version of filing F00151 without delay. This concludes my second oral order. And Madam Court Officer, we can move back to public session.
Your Honors, we're back in public session.
Thank you, Madam Court Officer. Let's now move to the first topic that was listed in the scheduling order, which is disclosure. I will give the floor to the parties on the disclosure of each category of material, as usual, starting with the Rule 1021B material, which is the material the SPO intends to present at trial, the Rule 1023 material, which is the material relevant to the case as listed by the SPO, the Rule 103 material, which is exculpatory material, the Rule 107 material, which is protected material for which the consent of the provider is requested. Just before doing so, I noticed that disclosure package 36, which was released by the SPO on 23 February 2022, does not contain any documents. Could the SPO elaborate on the reasons why this disclosure package was empty? So we have explanations on the record. Mr. Prosecutor.
Most certainly, Your Honor. As we have already informed the defense, we withdrew disclosure of two previously disclosed items that were disclosed in January. And my understanding is that the withdrawal of these two documents from the legal workflow system prompted the release of an empty disclosure package. That would be package 36. That we did not mean to include anything in that package. We just withdrew items, and that was the technical consequence of that action on our side. I hope that satisfies the court.
So it is a function of legal workflow that could be improved. Mr. Nielsen, do you want to add any explanations as the legal workflow master in this courtroom?
If I'm the legal workflow master, in this room we have a problem. No, I have nothing to add on this, fortunately.
Maybe if you could follow up and see if this kind of function could be deactivated for the future, because there's no need to have empty disclosure package, because I guess it triggers a lot of questions from the parties and from the bench, obviously.
Most certainly, Your Honor. We will follow up. Thank you.
Thank you, Mr. Nielsen. Let us now move to the material the SPO intends to present at trial. I thought we would be done with this category of material, but unfortunately it seems that it's not the case, because on 17 February 2021, the SPO gave notice of disclosure of one new item falling under Rule 1021B, and further sought leave to add this item to the list of materials to be relied upon at trial. On 2nd March, the defense indicated that it does not oppose the request, but that as a result of the delayed disclosure, it has to reassess the material it has to already processed, which causes delay in the preparation of its case. The defense also noted that it reserved its right to seek an appropriate remedy for the prejudice suffered as a result of the delayed disclosure. At the outset, I note that the time limit for the disclosure of material falling under Rule 1021B of the rules has expired. Thus, as opposed to disclosing the item in question, the SPO should have first requested permission to do so. The parties cannot decide on their own timeline. We have a legal framework, and I intend to enforce it. So I ask the SPO to recall its submissions and the defense to respond. And first, could the SPO indicate if we need to go into private session to address this matter?
I don't think that would be necessary, Your Honor. I think I can make my submissions in public session.
Thank you. Then you can proceed, Mr. Prosecutor.
Your Honor, with the court's leave, I will address this issue briefly. But at the onset, I just would like to remark the fruitful inter partes cooperation that we have enjoyed with the defense since the last status conference. Thanks to frequent, frank, and open communications, and thanks to the defense's professionalism, we have been able to resolve a number of issues inter partes. We look forward to continuing to do so as the proceedings proceed towards the trial stage. Now, coming to Your Honor's question, the prosecution is aware of the deadlines imposed by Your Honor, including that for the disclosure of Rule 1021 materials. We felt it was our obligation to disclose this document. As we explained, this handwritten document was translated and processed for disclosure as soon as it became apparent that the report that we had disclosed concerning these handwritten notes did not contain all the information contained in the notes. Now, this was a highly unusual situation, Your Honor, because generally these handwritten notes essentially reproduced a verbatim record of the first meeting that SITF staff had with that witness. It was a situation that we did not expect. Upon review of these notes, we realized that, in fact, these notes were an almost verbatim record of the meeting. We went to compare them with what we had disclosed, and we realized that we owed the defense more information that was contained in the notes. And that's why we proceeded to their disclosure, requesting leave to add them to our exhibit list. But we understand that Your Honor's preference in this regard and instructions are to request leave should any further disclosure become necessary, and we'll certainly be doing so.
Thank you, Mr. Prosecutor. Mr. Gillissen, please.
Thank you, Mr. President. On the disclosure on Rule 1021B, we receive a disclosure of some of the withheld items from the SPO. It remained 12 items covered by the 12 July 2001 decision, and we are waiting for the fate of 2 of them. All of we can say at this stage that we encourage the SPO to reassess the need of withholding its items to avoid any kind of difficulties 30 days before the trial, because we could have some problem to discover some new element, and I would like to avoid this situation. So it leads me to my second point. The second point concerning the disclosure of a prior statement of a witness. We didn't oppose to the addition to the list of exhibits of these new items, because despite the late disclosure, because it was a very late disclosure, we believe that this document will be relevant for the defense. But we have to note that this late addition to exhibit list should be treated with high conscience. The reality, Your Honor, that we always are in a situation where we have to reassess this prior statement in light of all the other statements already received before concerning this witness. And I would like everyone to realize this is prejudicial for the defense, I want to say, for its efficient preparation for the trial. My final point on this issue is that I kindly but strongly invite the SPO to carefully review the material for the disclosure under Rule 103, because we believe these items should have been disclosed as exonerating material at an even earlier stage. This would have been better for our organization, and I regret to be obliged to come back on work already made. But I understand all the difficulties we have all to face. Thank you, Mr. President.
Mr. Jelissen, do you wish to ask for any remedy?
The damage is done, Mr. President. Now we just have the hope to receive in the proper way all the documents we have to receive.
Thank you, Mr. Jelissen. Mr. Prosecutor, do you want to reply?
Briefly, Your Honor, we don't accept that the prejudice that counsel states stemmed from this disclosure is in fact, we don't accept that there was any prejudice. A note of the meeting with this witness was already disclosed to the defense. Now, it is true that the handwritten notes contain more details, but these are details that were already contained, this information is already contained in other statements of this witness. To the extent that there may be details that were not contained there, we're talking about details, Your Honor. There's no new facts. It's not a change of direction of the prosecution case. So when we hear about prejudice, we're skeptical, and we actually take issue with that and reject that proposition.
Mr. Ayouni, very briefly then, please.
Thank you, Your Honor. We don't accept the recognition and acknowledgement of a prejudice, and we can tell Your Honor, at this stage, we identified at least 3 discrete facts or elements that we did not see in other statements. Mr. Jelissen has pointed that we believe, and this is the reason we have to put it on the record, that we didn't oppose this document. The addition to the exhibit list is that it is relevant for the defense. And we invited the SPO to reassess whether it should be disclosed under the Rule 103. We have multiple statements from this witness, and without having the full picture of all the elements in their chronology, having a late disclosure of one document in the middle of the chronology leads us and forces us to reassess a number of issues. This is not an easy task. And the prejudice is there. On one part, if indeed this is Rule 103 material, it should have been disclosed way before. And of course, because we do not accept that the deadline should be skipped in the disclosure of material that will be used at trial. This is our basic right, Your Honor. Once we assess with other things the extent of the prejudice and the impact of this late disclosure, this is a discrete fact. It's a couple of items. But in general, when we put this in a general context, we can move, Your Honor, for a remedy, but not on a single occurrence. This is not our practice. Thank you, Your Honor.
Thank you, Mr. Ayouni. Having heard the parties, I will issue a third oral order. I note that while the newly disclosed item contains some additional information, The primary information contained in this item had already been provided to the defense by means of an item previously disclosed in accordance with the relevance time limit. Furthermore, the defense does not object as such to the disclosure. In addition, I observe that the SPO has disclosed merely one item and the case file is yet to be transmitted for trial. On this basis, I consider that this allows sufficient time for the defense to assess this disclosure, even though it indicates that it will lead to a delay. In these specific circumstances, I grant the SPO's request to add this item to the list of materials to be relied upon at trial. Furthermore, the SPO shall submit a public redacted version of filing F00149 without delay. Similarly, the defense shall submit a public redacted version of its response, which is filing F00162, after receiving the public redacted version of the SPO's request. And this concludes my third oral order. Mr. Prosecutor, I've previously underlined the necessity of seeking judicial authorization regarding disclosure-related matters to the SPO. I emphasize that I don't intend to entertain any disclosure matters in relation to which the SPO proceeds on its own motion prior to requesting judicial authorization, and I hope this is clear.
This is understood, Your Honor.
Thank you, Mr. Prosecutor. Before we move to the Rule 1023 material, I would like to ask the parties if they have any submissions on the new witness entities created in legal workflow. In its written submissions, the SPO indicated that it will start linking the Rule 1021 material to the relevant witnesses. It also noted that the process is ongoing and will be concluded before the start of the trial. The defense indicated that these entities in their current form are of little use as they do not link the disclosed material with the proposed witnesses in question. I would like the parties to indicate if inter partes discussions are ongoing on this topic and if the defense is satisfied with the presentation of the witness entities in legal workflow and the pace of the linkage by the SPO. I would like to give advance notice to the parties that I intend to set a deadline for the completion of inter partes discussions on this matter at the end of today's status conference. I further invite the defense to indicate if they intend to seize me on this matter. Mr. Prosecutor first.
Thank you, Your Honor. We pretty much stand by our written submissions in that the linking is in the works. We have, I understand, 5 witnesses which are almost ready to be released with the related and associated documents and exhibits, and will be doing so as soon as possible. This is the extent of the update that I can give Your Honor this time.
And I'm sure you know what's the question coming.
Yes,
What does as soon as possible mean? Because as we all know, when you put as soon as possible in any piece of rule or regulation, it doesn't mean much. So I always prefer to have a number.
Your Honor will be pleased to hear that as soon as possible means next week.
I am pleased to hear that. Thank you, Mr. Prosecutor. Mr. Ayuni.
Thank you, Your Honor. Just to confirm that on the day of the release of the witness entities, empty folders, at that stage, we happened to have a meeting with our colleagues from the SPO and we addressed this matter. We came to the agreement that they will not only populate the witness entities with the full names, last names and first names, which is important for us, but also, and most importantly, make the linkage between the documents, which is the purpose of these witness entities. We welcome this new information that we have part of the witness entities that will be disclosed next week, and we welcome your deadline for the matter to speed up. But we are in agreement that it is a matter of high importance between the parties. Thank you, Your Honor.
Thank you, Mr. Ioni. Just a follow-up question to the prosecution. You mentioned that it is going to be next week for 5 witnesses, and for the other witnesses.
Your Honor, for the other witnesses, at the moment, I'm not in a position to give you an exact date, but we will be working continuously on this matter, and we will be releasing witnesses that will be linking documents to the already released but somewhat empty at the moment witness entities as we proceed and as soon as possible. This time, for as soon as possible, I do not have any more precise indication.
Thank you, Mr. Prosecutor. If you could keep the defense informed about the pace of the linkage, that would be much appreciated so that the defense can take this into consideration if they have any comment both on the linkage itself and the pace of the linkage.
We will certainly do so, Your Honor.
Thank you, Mr. Prosecutor. Let us now move to the disclosure of evidentiary material relevant to the case, which is the Rule 102.3 material. The SPO indicated in its written submissions that it has disclosed all materials falling under Rule 102.3 requested by the defense, with the exception of documents which are included in the pending protective measure requests and documents falling under Rule 107. Given that I ruled on the 2 outstanding protective measure requests earlier this week, I invite the SPO to confirm that only disclosure of documents falling under Rule 107 and the items for which I decided to defer my decision this week is pending for the Rule 102.3 material requested by the defense. In its written submissions, the defense indicated that the parties are making efforts to resolve inter partes all issues arising related to disclosure. However, the defense repeated its concern about the insufficiency of the description of some of the items listed in the prosecution's Rule 102.3 notice. It also noted that important material was only identified following a number of requests to the SPO. The SPO, on the contrary, still considers that the notice is sufficiently detailed and confirm its availability for inter partes discussions to clarify the description of some items on a case-by-case basis. I welcome these inter partes discussions, but they cannot last forever. Disclosure of Rule 102.3 material has been ongoing for nearly half a year now, and it's now time to finalize these discussions. So, as I did earlier, I would like to give advance notice to the parties that I intend to set a deadline for submissions of any request regarding the disclosure process. And I further invite the defense to indicate if they wish to file any request regarding the description of the items listed in the Rule 102.3 notice or any other request related to the disclosure process. Mr. Prosecutor.
Thank you, Your Honor. For the, with regard to the disclosure of the items on the Rule 102.3 list, I can confirm that we will be disclosing the items ruled upon by Your Honor in the 2 protective measure decisions within the deadline and within the, according to the modalities set by Your Honor. And that there are a number of Rule 107 documents. We'll be discussing those later in the agenda, but that they will also be added now that we've obtained clearance to the Rule 102.3 list, further after seeking leave to do so. But we have also found another document which does not fall under Rule 107 and that was requested by the defense, but that we have not disclosed. We will be, the defense is informed, and we will be disclosing this document as soon as possible. It's a document in Serbian language, which we will be providing with the translation, and we will be disclosing that without delay, Your Honor. With regard to the descriptions of the items on the Rule 102.3 list,
Mr. Prosecutor, just before we move to the description, if you don't mind, is there any reason for this less disclosure, first? And second, can you confirm that you don't dispute the materiality for the defense?
I can confirm we do not dispute the materiality for the defense. The document, Your Honor, we were waiting for a translation, and it should have been included in a previous disclosure, and it was not.
Thank you. You can proceed with the description of
Yes.
the items.
With regard to the descriptions, Your Honor, further to additional discussions with the defense, we have reached an agreement, and we will be reviewing the the documents in our Rule 1023 list, which have not yet been requested by the defense or otherwise disclosed to them, for instance, pursuant to Rule 103. We've communicated to them that we will be beginning this work without delay, and we will be in a position to inform them when, and Your Honor, of course, when a revised revised descriptions for these outstanding items will be ready. So we believe that by the end of next week, we will be in a position to have a fairly precise indication of when we can provide these revised descriptions to the defense.
Thank you, Mr. Prosecutor. Mr. Gilsen, please.
Thank you, Mr. President. About the disclose on Rule 1023, been notice of items relevant to the defense, and purely on this basis, we can report that we have selected the items that the SPO list is supplemental list, and we receive all of them. We receive all of them in the package 32 on 8 February 2022. So what remains now, as you say, we are waiting for the materials that we selected and for which protective measures are involved. We just have to add that we held fruitful inter-party discussion, as you know, and our colleague of the SPO, we are discussing about the description of the items. That's a big issue, of course, and the notice, and about all the things. But I think we will continue to endeavor our situation and discussion. That's sure. I'm very confident with. I think we are in progress in this situation. Thank you.
Mr. Gilisen, can you confirm that you will not have more Rule 1023 items request from the notice that the prosecution sent you? Sure. Mr. Ioni, please.
Thank you, Your Honor. Just for the technical issue, and after the discussions we had today with our colleagues of the SPO informing us that they acceded to our request to review the descriptions of the items that we have not selected. So this was the main issue we had in the last States Conference. Obviously, we commend our colleagues' reasonableness and courtesy in acceding to our request, which is fair. We have proceeded with a list of examples of why we need specifics in certain items. Now that we will receive new descriptions of items that we have not selected, we should be allowed some time, because this is what we wanted to avoid, to miss documents due to lack of descriptions. We will need some time to review them and point to the documents that we would have otherwise selected. So at the time when we receive a new update, that would be a time frame to set for us to select for. And as Your Honor knows, for the supplemental list, we acted without deadlines, but we acted very quickly, both in terms of selection of the documents and disclosure from the other side. So we're endeavoring. Thank you.
Thank you, Mr. Ioni. Let's talk timelines then. Mr. Prosecutor, when will you be able to provide the defense with an updated list?
Your Honor, we'll be in a position to have that estimate once we start working on this review and we see at what pace we can proceed with the resources we have. As I said, I think that by the end of next week, we'll be able to provide a fairly, hopefully accurate estimate, which we'll be happy to inform Your Honor about as well, if Your Honor would like that.
So end of next week, you will be able to inform me of
And
when,
the defense.
and the defense of when your updated notice will be able to be finalized, correct?
Yes, Your Honor. There are approximately 1,700 items that have not been requested by the defense or otherwise disclosed by the prosecution proprio motu. So that might take a bit of time. It requires opening the documents, and we need to take stock of the situation and evaluate the time that the task requires.
Thank you, Mr. Prosecutor. Mr. Ioni and Mr. Gilsen, how long do you think you need once you get the updated list? But then, of course, it depends if there is one general update or if it's updated piece by piece.
Your Honor, we proceeded with an Excel spreadsheet in the first parts of the process of the notice. If we receive batches of updates, we can proceed with those. Obviously, we will try to move as soon as possible to select those that are relevant to us. For the complete notice, we had around 4 weeks or 6 weeks. We believe that 2 weeks, this is probably half of the amount. We have gone through a lot of them, but we have to go through them with fresh eyes. So maybe 2 weeks after we received the updated list could be sufficient for us to make our selections.
Thank you, Mr. Ioni. Mr. Prosecutor, do
Sorry.
Sorry.
Sorry, Your Honor. I had one more point on the notice and
Please.
on the descriptions. There is one pending issue we are still discussing with the SPOs. We didn't receive a number of the items we have selected because they are contained in some other documents or duplicates of other documents. And we are continuing the discussions with the SPO to indicate for which items they are duplicates of. This helps us to ascertain what we have, because sometimes the descriptions are not complete and the description of a full document is not the same of the extract of it. This helps our process as well to speed up the to make it more efficient, just to put it on the record. Thank you.
And last question on these category of items. Do the parties think they can resolve everything inter partes? I mean, do you think that you are able to satisfy the defense expectations in terms of precision for the notice? And on the other side, do you expect that the prosecution will be able to provide you with enough information and deliver it in a timely fashion so that you can finalize your investigations in a reasonable time frame, Mr. Prosecutor?
Yes, Your Honor. The defense requests so far have been reasonable, so we have no doubt that we have no reason to believe that we won't be able to answer them in a satisfactory manner.
Thank you, Mr. Prosecutor. Mr. Ioni?
Yes, thank you, Your Honor. The big news and the game changer came today, where the SPO accepted to update the descriptions. We believe this was the biggest holder that could lead us to seize you with a request for ruling. So we are very optimistic that we will resolve it out of court. We are convinced that we will be able to do it. Thank you.
Thank you, Mr. Ioni. Let's be optimistic then, especially in terms of the time needed to update the description of the 17,000 documents. And I'm especially looking at the disclosure officers in the back, because a lot of things will rely on your efficiency. Let us now move to the Rule 103 material. In its written submissions, the SPO indicated that it had not completed the review of all material falling under Rule 102.3 for potentially exculpatory material, but was on track to do so before today. So I invite the SPO to give an update on their review, and I strongly hope that the SPO can confirm that it is now finalized with the review of exculpatory material. I also invite the SPO to indicate if protective measures are requested for this category of material, given that it indicated in its written submissions that it aimed to file a comprehensive request for protective measures after it has finished its review. And finally, I invite the SPO to indicate whether it has additional exculpatory material to be disclosed to the defense. Mr. Prosecutor.
Your Honor, before I begin, just a matter for the record to be correct. The descriptions that we need to review are not 17,000 but 1,700. I know that Your Honor probably understood us, but the record now speaks about a much larger number, and so I wanted to be clear that it's in fact 10 times less than that.
I was probably scaring everybody with this, but it's indeed 1,700, which means that it can be 10 times faster, no?
Your
So
Honor.
it's actually good news for the pace of our proceedings.
Now, Your Honor, with regard to the disclosure of exculpatory items, we have completed our review and disclosure of exculpatory material contained in the Rule 1023 notice. We have concurrently, today, filed a request for protective measures for 5 items. Now, we have filed it late this morning, so it hasn't been distributed yet, but I understand distribution is in the works, and we are hopeful it will be distributed to Your Honor today. The request is filed in inter partes and strictly confidentially so far. We will be following up with a confidential redacted version without delay. So, with regard to documents that we have not disclosed to the defense, we are not aware at the moment of other potentially exculpatory materials. Of course, with the caveat that the office continues to investigate, and so there will be reviews periodically. But at the moment, Your Honor, we can communicate that we have finished this review and disclosure, apart from the 5 items that Your Honor will have to rule on.
Thank you, Mr. Prosecutor. This is excellent news, and I just checked. I still haven't received the request, but I'm sure it's going to be processed before the deadline. Mr. Gillissen or Mr. Ini? Mr. Gillissen.
Yes, thank you, Your Honor. For the exonerating material, we take note of the progress of the SPO in this review of the notice for this exonerating material. We receive 380 documents, but yesterday and today we receive more. We receive package number 30, 38, 39. It means 111 items yesterday and 25 today. So, things are running, I can say. And our colleague before yesterday informed us that a similar number of items should be expected in future. So I suppose we will be busy with, among the others, all these elements, the voluminous material already received, and of course the one yet to be received. So the next week could be very busy. Thank you.
Thank you, Mr. Gillissen. Mr. Prosecutor, do you
Yes,
want to add
Your Honor,
anything?
just one thing I wanted to clarify. I should have done it earlier, that the 111 items that were part of one of the 2 packages were documents that we had already disclosed to the defense, and we repackaged them under Rule 103. So these were not new documents.
And they had been disclosed under Rule 102.1b or 102.3?
102.3, Your Honor.
102.3, okay. Thank you for this precision, Mr. Prosecutor. Let us now move to the Rule 107 material. In its written submissions, the SPO indicated that one additional document was cleared at the end of January 2022. However, for 12 documents, clearance has been denied, and the SPO will be filing a Rule 107.2 request in this regard. I would like the SPO to give more details on this material, the anticipated timeline for obtaining clearance and completing disclosure, and the timeline of any request related to Rule 107 material. Mr. Prosecutor.
Yes, Your Honor. Since our written submissions, we have learned that more documents have been cleared. We are talking about approximately 10 documents cleared under Rule 107, and approximately the same number of documents for which clearance has been denied. So, as we announced, a Rule 107.2 application is forthcoming in that regard, as required by the rules, in which we will be listing the documents for which clearance has been denied, as well as documents that have been for which clearance has been provided with reductions applied by the provider. These documents, approximately, as I said, 10, will, of course, be added through the appropriate procedural avenue to the Rule 102.3 list. We expect to be able to work on these two filings in the coming weeks, as soon as practicable, considering concurrent obligations, some of which we will be discussing further down in the agenda.
Thank you, Mr. Prosecutor. Mr. Ayuni, please, do you want to, or Mr. Gillissen, do you want to add anything?
Mr. President, we just take note. We are waiting for. That's all.
Thank you, Mr. Gillissen. Let us now move to the issue of translations of filings and evidentiary material. In its submissions, the SPO indicated that it has not received further requests for translation since the last status conference. The SPO also maintains its general position that it is only obliged to provide translations in accordance with the rules set forth in the framework decision on disclosure. I would like to hear the parties on any further issues regarding translations, and I specifically invite the defense to indicate if it intends to file any requests regarding translation of items listed in the Rule 102.3 notice. Mr. Prosecutor, first.
Yes, Your Honor. I do have an update for the issue of translations compared to what we submitted in writing, which is that the translation and transcription of videos that we disclosed in package 34 are now ready, and we will be disclosing them to the defense shortly. Further, the defense has sent an inter partes request for translation of 4 items, 2 of which we had disclosed pursuant to Rule 102.1b, and the other 2 pursuant to Rule 103. These translations are also ready and will be disclosed shortly.
Thank you, Mr. Prosecutor. Mr. Gillissen, please.
Yes, Mr. President, we have to report that we recently requested from the SPO translation of a number of documents on Rule 102.1b. We received this document and we want to thank our colleague from the SPO for that. So more recently, we request translation of 2 documents on the same basis, and the SPO indicates that they will provide us with some Albanian translations, so it is very useful for them. And I thank you, really, I thank you, the prosecutor, with that. Finally, as a matter of courtesy, we request translation of document disclosed on rules 102.3 and 103, and the SPO indicates the agreement to provide us with full or in-part translation. We thank them for their professional courtesy. That's really a pleasure to try to work in such conditions. I want to underline it. Thank you.
Thank you, Mr. Gillissen. Mr. Nielsen, any submissions related to translations? Is there any backlog in what has been requested by any of the parties?
No, just maybe an update, Your Honor. So the pretrial brief, which was filed at the end of January, that has been translated. Upon request, it was provided to defense already on the 9th of February, and it has then later been revised and filed on the 25th of February. And as far as the registry is concerned, there are no outstanding prioritized requests for translation. Thank you.
Thank you, Mr. Nielsen. Let me now move to the next item in our agenda, which is the status of the SPO's investigations and next steps. Before discussing the matter further, I would like to SPO whether it is necessary to go into private session in this matter.
Well, it might be prudent to do so.
Madam Court Officer, can we go into private session, please?
Your Honor, for the record, we're now back in public session, and we had moved already to private session when counsel for the prosecution stood up. Thank you.
Thank you, Madam Court Officers. It was probably one of the shortest private sessions ever in this court. Mr. Prosecutor, you can proceed.
Thank you, Your Honor. We have taken the necessary steps from our side to carry out any outstanding investigative measures and steps as soon as possible. Your Honor, we are now waiting to hear back from the competent authorities, and we will be ready to begin as soon as we receive this response. Now, the timing of this response is not something that we can control, although we've done all we can to ensure that this response can come in a shortest possible time. Realistically, Your Honor, we are hoping that we will be finished with this investigation within the next 2 months, hopefully less. Again, it really depends on the timing of the response that we receive from the competent authorities. As soon as we receive this response, we are ready to start. We believe that the completion of these investigations will not take long, and as soon as completed, we will start processing any evidence that these investigations generate for the prompt disclosure to the defense. Now, I'd like to stress, Your Honor, that the evidence that we expect will come out of these limited investigations will not change the character of the prosecution case and will not force the defense to rethink their case and strategy. So, as we stated before, this evidence is, we expect this evidence to be of a corroborative character. And for these reasons, it is our position that these pending limited investigative steps should not prevent the proceedings from continuing to follow their course towards the trial stage. That concludes my submissions on this issue, Your Honor.
Thank you, Mr. Prosecutor. First of all, I'm a bit surprised because in your written submissions, you mentioned the date of April, I think, or early April, if my memory is correct. So I was expecting that you would be done earlier than that. Do you really need 2 months, you think? Because that's quite long, given where we are in the proceedings. And the second thing is that I understand that you're not going to build a complete new case from now, but again, I stress that we are more than 2 years after the indictment has been filed, and we are nearly 1 year after the arrest of the accused. So I'm a bit surprised, to say the least, that we are still in this phase at the moment.
Your Honor, we understand the court's concern, and our time indication of 2 months is just not to give expectations on matters that are somewhat out of our control. As if we may go into private session, Your Honor, perhaps I could explain myself a bit better.
Then we will move to private sessions for these explanations. Madam Court Officer, if you can proceed.
Your Honor, we're back in public session.
Thank you, Madam Court Officer. Mr. Gillissen, please.
Yes, Mr. President. I can say we take note, but it's a little bit insufficient. This is a real problem of this procedure. We are more than 20 years after the alleged facts. I understand absolutely the problem of the prosecutor because, of course, we are meeting the same. So now it's long, and it seemed to me that a judicial control could be a nice thing, because really I know that's a delicate question, and it's now very long, of course. Thank you very much.
Thank you, Mr. Gilsen. Mr. Prosecutor, in your written submissions filed on 17 February, you indicated that the SPO will endeavor to conclude its additional investigative steps by 1st April 2022. So this is now an old timeline that you cannot follow. Is it how I should understand your submissions?
Your Honor, we are still aiming for that timeline, but I decided to give an update to the court that takes into account that what we're aiming for is not something that is completely within our control. We're aiming for that. We're hopeful that that can happen within that timeline, and we've taken all the steps that we could in order to put the competent authorities in a position to get back to us as soon as possible by providing detailed information on what we need and other steps that our experience teaches us enables competent authorities to respond more promptly to these types of requests. But that is, Your Honor, the extent of what we can do, and we're just waiting to hear back from them. That's why today I provided an estimate which may have surprised Your Honor, but it is realistically, it could be possible, although we hope not.
Thank you, Mr. Prosecutor. But you understand that when you continue your investigations for 2 more months, it means that in 2 months we're going to have new 102.1b material potentially disclosed to the defense. Then it means that the defense cannot conclude investigations, which means that they cannot finalize their pretrial brief, which means that the transmission of the case is delayed by exactly the same number of months. So that's what it means in practice. So, I mean, I understand that the reasons that you mentioned, but still I want to insist on the fact that it has huge implications not only on your investigations, but on every step that has to follow in the pretrial proceedings.
Your Honor, again, I'm hesitant to commit to any specific date, even though I understand the importance of that, and I understand why Your Honor is insisting that we are as precise as possible. But I'm hesitant because, as I said, it's something which is not fully within our control. Now, when I said 2 months, in my mind, I had also that within this timeline, we would complete also the disclosure-related steps to these investigations. But again, Your Honor, it is something that I don't like to promise something that I can't control. And this is the case, Your Honor, in which some parts of this process are outside of our control. But we have done our best to ensure that the other parties are in the best possible position to act quickly. Now, we can endeavor to keep Your Honor informed of any progress on this front as soon as we receive information.
That would be much appreciated. I also invite you to inform the defense as well. Mr. Gilsen, you want to add something?
Yes, Mr. President. I want the fair trial for Mr. Shala, and I want to be fair with the prosecutor. But I have to say I'm not convinced with the necessity of such investigation at this moment. I'm not sure that's really a necessity, and that's why I consider that a judicial control could be necessity, a real necessity. Thank you.
Thank you, Mr. Gilsen. Just one last remark, Mr. Prosecutor. In your 2 months time frame, don't forget to include the time you have to factor in to request the authorization to disclose new 102.1b material.
That is understood.
Thank you, Mr. Prosecutor. For the next point on the agenda related to defense investigations, I would like to turn to the defense first. I note from the defense written submissions that it is still unable to provide any information on the anticipated duration or status of its investigative activities. I also note that the defense at this stage is not able to confirm whether it will make any request concerning unique investigative opportunities and whether it will provide notice of an alibi and or any grounds excluding criminal responsibility. In its written submissions, the defense confirmed its intention to file a pretrial brief in due course, but indicated that at present it is impossible to provide an indication as to when it will be in a position to do so. As indicated in my scheduling order, I intend to set a timeline for the next steps for the pretrial phase. It is true that there are a few items that have been recently disclosed to the defense, but the defense now received the pretrial brief from the SPO and a very substantial part of the evidentiary material. So there is no reason now for the defense to delay its investigations. So I invite the defense to provide any additional information and notably a clear timeline for its investigations and the submission of a pretrial brief, if any. Mr. Gillissen, please.
Yes, Mr. President, we already have started with our investigation and proceed with important steps. That's a very big point in my opinion, Mr. President. However, we still have to go on the ground during the months of March and April for investigation for more important steps. As I told you, as I said, we are working more than 20 years after. To find some documents now, that's very painful and very difficult. To find some witnesses in life could be a delicate business too. And to find reliable witness, it's a huge, difficult business. So I understand, of course, the will and the willing to proceed. We are proceeding. And it's that's really difficult. The prosecution its own investigation till some years. We're just starting till some weeks in very high, difficult conditions. We have the disease. We have some forbidden area where it was impossible to go. So we need time. I don't say we need some years, of course, or even some very important months, but really we need it. We need because almost every day when we are on the ground, we discovered some elements that could really be interesting for the defense of Mr. Shala. And I want to say that in the meantime, we have made some progress with the forensic part of our investigations. We expect to continue this very important work during the next months and to be able to tailor and focus our investigation when we have analyzed and processed all the material disclosed in the case. It's, as you said, Mr. President, it's the next, of course, it's a difficult task. So that's why it is, in my opinion, totally premature now to be able to have a concrete idea at this stage about a possible alibi defense, but it could be. We are gathering some elements, but an alibi defense is something very difficult because it must be a whole and not in part, and not a puzzle. That's why we need some time to be on the ground. And it is the same about a unique investigative opportunity. This is the same about any commitment concerning the filing of a pretrial brief. We know and we can confirm our intention to submit a pretrial brief on behalf of Mr. Shala, but in all honesty and transparency, I can say that any discussion about a possible date concerning a PTB now is totally unrealistic at this stage, because just what I say before. I don't say we need a lot of months, but things are building. And so lately, more than 20 years after, of course, the process is slow. I make my best for a process not too slow, Mr. President. Thank you.
Thank you, Mr. Gillissen. You just said, and I read the transcript, I don't say we need a lot of months. Shall I interpret that as a few months will be sufficient?
A few months, Mr. President, what is the size of a few months? So, in my opinion, before 2, perhaps 3 months, it seemed to me it's difficult. But I will be able, in my opinion, to answer more properly during mid-May, I think so. I think we could have a real possibility to provide a real quality answer.
Mid-May is already in 2-3 months, Mr. Gillissen.
Yes, Mr. President, I know perfectly well, but I can say, even in public, we have to go on the ground in March, in April. If we will succeed in our research, no need more, but it's a possibility to go one more time on the ground. It's a possibility, and I don't want to hide it, to your honor. Thank you.
Thank you, Mr. Gillissen. So I take from your submissions that you need at least 2 months, and then within 2 months you will know if you need more, correct? Thank you, Mr. Gillissen. Mr. Prosecutor, do you wish to
No,
make
Your
any
Honor,
submissions?
we don't have anything to add. Thank you.
Thank you, Mr. Prosecutor. Mr. Ayuni, you want to add anything?
A couple of points, Your Honor. 2 facts, important facts. We received the PTB, and there are a lot of names in the PTB, and there is evidentiary material in the PTB.
Just for the public, PTB is pretrial brief.
Pretrial brief, sorry, Your Honor.
Understands.
A number of names, to put it as general as possible, are mentioned in the pretrial brief, for which there is evidentiary material and for which there needs to be investigation. And so the number of witnesses that the SPO chose to call in the trial is not the only indication of what is needed for us to present and to frame our defense. This is a highly important element that we need to put in the record. The other element, Your Honor, is that Mr. Shala has spent the last 20 years outside of the ground, which is an enormous factor in our processes. Those are the 2 points that we wanted to add and put on the record in relation to the investigations. Thank you, Your Honor.
Thank you, Mr. Ayuni. Let me now move to the next item in our agenda today, which is the points of agreement on matters of law and fact. We discussed this topic in several status conferences already, but the parties have always indicated that they were not in a position to make any progress on this issue so far. I know that the parties have recently had some preliminary inter partes discussions on how to most efficiently proceed on this matter. So the discussion seems to be limited to the process at this stage and not to the substance. Again, this is nearly a year after the pretrial phase began. So the SPO has started to draft a first set of proposed facts and anticipate being able to forward those to the defense before the next status conference, if I understood correctly from the SPO's written submissions. But I want to stress to the parties that it is now time to conclude these discussions. Either the parties are able to agree, and this is recorded in the case file, or they are not. And I will take note of this in the handover document, but we will not delay the proceedings for this, which is not necessary to go for trial. So I invite the parties to give a clear timeline for completing their discussions. And I would also like to give advance notice to the parties that I intend to set a deadline today in relation to this matter at the end of the status conference. Mr. Prosecutor.
Yes, Your Honor. We have sent a set of facts, proposed facts for agreement to the defense on February the 22nd. And so we are waiting for their response on these facts. And depending on the response, there may be more attempts at finding further agreement, but it's also possible that we will leave it at that.
Thank you, Mr. Prosecutor. Is your proposal exhaustive, or are you going to make another proposal?
Well, Your Honor, as I said, we proposed a number of facts for agreement that we consider perhaps to be more palatable as a first attempt, and whether the prosecution and perhaps the court wants to devote more time to attempt to propose more facts, I think will depend on the agreement that we managed to reach on these facts, which may be characterized as perhaps less controversial, at least from the SPO's point of view.
Thank you, Mr. Prosecutor. Mr. Gillissen, please.
Thank you, Your Honor. We receive a first list of proposed point of agreement from our colleague of the SPO, and that's the big issue. It is the first list or not. Oh, I want to thank my colleague because we receive an Albanian translation of the list, and it's very simple for us to discuss with Mr. Shala. On this list, I think I'm able to say we will be able to provide some answers in 1 week. I don't need more time, I think so. So for the rest, it depends if there is a second list, of course, Mr. President.
Thank you, Mr. Gillissen. Mr. Prosecutor.
Your Honor, I maintain my position that whether there will be a second list and a second attempt will depend on the answer on the first attempt.
So this is a cliffhanger. Nobody knows what's going to happen, but I appreciate that the parties have moved on since their written submissions, that the proposals has made a formal proposal to the defense, and I appreciate, Mr. Gillissen, that you mentioned that 1 week should be enough for being able to get back to the SPO on this matter. So I invite the parties to keep this pace, so the points of agreement on matters on law and fact can be finalized within the following weeks. At this point, I will break for probably 25 minutes, in a couple of minutes, but before that, I would like to ask the parties whether they have any other specific issues they would like to raise, issues that were not on the agenda today. Mr. Prosecutor.
No, Your Honor, we don't. Thank you.
Thank you, Mr. Prosecutor. Mr. Laws, would you like to raise any specific issue?
Your Honor, no thank you. We have no submissions in relation to the topics on today's agenda. Thank you.
Thank you, Mr. Laws. Mr. Gillissen, please.
So, Mr. President, I would like now to raise the issue concerning a particular procedure concerning a particular witness.
Do you wish us to move into private session, Mr.
Absolutely, Mr. President. Thank you very much.
Madam Court Officer, can we move into private session, please?
All rise. Please be seated.
Madam Court Officer, can we move back to private session, please?
Your Honor, we're back in public session.
Thank you, Madam Court Officer. Before we adjourn this hearing, I will now set a tentative calendar for the remainder of the pretrial phase. I remind the parties that in the order convening the present status conference, I announced that in the absence of a proposed timeline for the completion of the parties' pretrial obligations, I intended to set a calendar to this end on the basis of Rule 95(2)(a) of the rules. In this regard, I note, first, that the SPO submitted the indictment for confirmation in the present case on 14 February 2020, now more than 2 years ago. That the indictment was confirmed on 12 June 2020, and that Mr. Shala was arrested on 16 March 2021 in the Kingdom of Belgium and consequently transferred to the detention facilities of the Specialist Chambers in The Hague on 15 April 2021. I also emphasize that the charges brought against Mr. Shala are of a relatively limited scope. Second, that the SPO has in principle completed its disclosure of materials under Rule 1021B of the rules, with the exceptions of anything to be disclosed related to their investigations. That the disclosure process pursuant to Rule 1023 of the rules is nearing completion, and that the SPO has reviewed its list of items pursuant to Rule 103 of the rules for exculpatory information, and it has disclosed a significant numbers of such items. And third, I ruled on the defense preliminary motions on 18 October 2021, and that the Court of Appeals upheld these decisions on 11 and 22 February 2022. Nonetheless, I note that despite the passage of a significant period of time and notwithstanding the progress achieved, a number of pretrial obligations and issues remain outstanding. In this regard, I note in particular that, first, the defense continues to express concerns about the sufficiency of the description of some of the items listed in the prosecution's Rule 1023 notice, even though the parties have made some progress in their discussions. Second, that the defense intends to object pursuant to Rule 95(2)(e) of the rules to the admissibility of evidentiary material that has been disclosed on the basis of Rule 102 of the rules. Third, that the SPO is continuing to run searches and checks to ensure that all relevant potentially exculpatory content, in particular, has been identified and disclosed. Fourth, that the SPO continues to conduct investigations. Fifth, that the defense is unable to confirm at present whether it will make any request concerning unique investigative opportunities pursuant to Rule 99(1) of the rules. Six, that the defense is unable to indicate at present whether it will provide notice of an alibi and or grounds excluding criminal responsibility. Seventh, the defense confirmed its intention to file a pretrial brief in due course. And lastly, that the parties have indicated that they will conduct inter partes discussions in the coming weeks. In these circumstances, I take note of the fact that the parties consider that they are not in a position to specify a timeline for a number of pretrial obligations. However, I remind the parties of the accused right to be tried within a reasonable time under Article 21(4)(d), and the functions of the pretrial judge laid down in Article 40 of the law and Rule 95 of the rules, in particular the power to issue any necessary orders to ensure the case is prepared properly and expeditiously for trial. Therefore, I issue my fourth oral order on the procedural calendar for the remaining steps of the pretrial phase. First, I set the tentative date for transmitting the case file to the trial panel to 31st May 2022. In this regard, I wish to emphasize that while this is a tentative date, any request for postponement must be based on compelling circumstances. Second, the SPO shall submit any outstanding requests pertaining to the disclosure process, in particular requests concerning protective measures, by no later than 18 March 2022. The defense shall submit any request pertaining to the disclosure process by no later than 8 April 2022. This deadline shall also apply to any request the defense wishes to make regarding the matter raised in its submissions in private session before the break. Third, the SPO shall, with the exception of any material subject to any request regarding protective measures, complete all its pretrial disclosure obligations by no later than 22 April 2022, and it shall submit a notice in the record of the present case providing a detailed overview of the entire disclosure process by the same time. And finally, the parties shall finalize their inter partes discussions and submit their point of agreements on matters and law and fact by no later than 8 April 2022. This concludes my fourth and final oral order. Before we adjourn this hearing, I would like to ask the parties for their views on the date for the next status conference, which could be scheduled on Thursday, 14 April 2022 at 9:30 a.m. Mr. Prosecutor.
Will be available at that time, Your Honor.
Thank you, Mr. Prosecutor. Mr. Laws, please.
Oh, yes, I'll be available at that time. Thank you.
Thank you, Mr. Laws. Mr. Gillissen, please.
Yes, Mr. President, may I provide a full and complete answer on Monday?
Absolutely, you may.
Thank you very much.
If you can indicate this to the court management unit, and we will either confirm this to all the parties or try to identify another date if possible.
Okay, thank you very much. Kind of you.
Thank you, Mr. Gillissen. You will receive a scaling order in due course that will include the agenda before the status conference as usual. And this concludes today's hearing. I thank the parties and the participants for their attendance. And as usual, I thank the interpreters, audiovisual technician, stenographers, and security personnel for their assistance. The hearing is adjourned.
All rise.